Today we're going to begin the first lecture on freedom of speech. The first thing I'd like to point out is that freedom of speech does not mean it's absolute speech for everyone. No one has that. The idea is that if you're going to have absolute speech, you really put at risk others. In other words, someone else's speech or right has to begin at some point, and so no one has an absolute right to that. So one person's right begins where another person's right ends. So the government has to regulate those things. So there are some types of speech that are protected speech. There are others that are regulated, and there are those that are not permitted. Those that are not permitted, you'll see, are those that will cause some sort of issue or problem for the rights of others. So let's start off talking about dangerous speech. That's unlawful activity. And the state can prohibit that speech, advocating unlawful or subversive action for the reasons I mentioned. But let's lay a few of those out. The first is clear and present danger. Words that used in a certain manner and specific context where they would bring about a criminal harm. Schenck versus the United States deals with this. That's a case you should know. Speech that wants to overthrow the government by force. Now keep in mind, what the court has said is that we have a right to remove the government, but we do that based on elections. So we already have a right to correct what we might see as an unacceptable government or leader. So you can overthrow the government by force, and words that may cause harm by influencing others to undertake harmful acts, even those taught as advocacy of a certain doctrine. And this is in Gitlow versus New York, a case you should know, going back to 1925. The second, outside of outright unlawful activity, which is clear and present danger, and overthrowing the government, is incitement, which is the urging of a group or person to take immediate action. Brandenburg versus Ohio, another case you should know, which goes back to 1969. We'll review these cases, and you will get these cases sent to you, so you can look them over. Incitement, right? You can see why that's problematic as speech, because you're getting people to violate the law. That's what we mean by incitement. So you're really urging a group, right, to take immediate action. And first, that action is likely to cause harmful action. You're inciting people to do something that's going to negatively impact others or the government. So it's likely to cause harmful action. The second thing is that the speaker who is speaking has to intend the incitement or produce imminent lawlessness by that action. So you can say something that's not intended to incite, and it may incite others. But what the court looks at is, what was the intent of the speaker? Was the speaker to incite? For example, a comedian saying that we should go take a certain politician out in the street and behead them. It's a comedian. If that's done in the context of comedy, then the court would say the intention here wasn't to incite. The intention was to entertain. So it's got to be likely to cause harmful action. The second thing is that the speaker intends to incite or produce imminent lawlessness, right? So you got to keep that in mind. Think about the example of the comedian. And under incitement, it applies only where the speaker urges illegal action, right? So illegal action is important here, because if it's not, then obviously it's not a violation of free speech. And that's illegal action in opposition to the government policies or private parties. Think about that for a second. Incitement means you're getting others to do things that are illegal, and those are not protected. That's dangerous speech. First was unlawful activity. The second here is incitement. The important cases again is Schenck versus United States, Gitlow versus New York, underneath the unlawful activity, and Brandenburg versus Ohio under incitement. And there's three provisions there: likely to cause harmful action, speaker intends to incite or produce imminent lawlessness, And C, it applies only where the speaker urges illegal action in opposition to the government, government policies, or private parties. We're focusing on the government here because we're really concerned about two things, right? Overthrowing the government or causing some harm to the governmental structure. And why is that? Because the government is supposed to be protecting the rights of each individual, right? So it's not just the government itself, but if you eliminate the government, what you're really doing is you're eliminating the very source of the protections of the rights that individuals have. So consequently, you protect the government because the government is supposed to protect you. So individual rights really depend on the government being able to stop others. So when we look at freedom of speech, we're looking at two things: actions that affect the government and then actions that affect individuals. So you can't use your speech to incite, right, or post some sort of unlawful activity, because the government, source of protection of rights, could be eliminated, let's say in an extreme case. Then there's those things where someone expresses their view on something that actually don't necessarily deal with the government, but fundamentally can cause a problem for individuals. So under dangerous speech, we move now into an area where it's about the individual. And here, the first thing is fighting words. Now, fighting words are direct personal insults that are likely to cause a person to react violently. So when the court looks at this, the court has to really say, okay, well, look, what is likely to cause a person to react violently? Now, we don't really know. You can't define that up front, but there's a measure of reasonableness to this. The court would look at that and say, okay, this person didn't expect this person to say something. They said something very offensive about, say, the person themselves, and so that person responded. And then the question really is, was the response reasonable? Was the exercise of that particular speech reasonable? If it was, that casts the entire concern by the court in a very different light. Okay, so we really care about with fighting words is it bound to lead to some sort of violent reaction, right? Again, reasonableness. The court would have to decide, well, you say things like that in those circumstances, and people are going to be upset. So the idea with fighting words is that by stating them, you're going to cause someone to react poorly. I'll give you an example, not of a case, but of an incident. This is an actual incident. You've got several people waiting online for something, and one person is dressed in a military uniform that is obviously very old. And there's a man behind him, and another man behind that man. The man behind the man wearing the military suit says, "Hey, I want to thank you for your service." Now, this is many, many years after the end of the Vietnam War. I think it was 40 years or what have you. And the man behind the man that's behind the military guy says, the guy behind the military man says, "What war were you in?" And he says, "Well, Vietnam." The person behind the person who said, "Thank you for your service," says, "That was a stupid war, and I avoided it." Now, that's not really fighting words, but it is insulting. But it would not be reasonable for the military guy to say something to this guy, hit him, or what have you. Why? In large measure, it's because it's not a personal attack, right? He was talking about a war. He didn't say, "And you were stupid to go ahead and fight." That might have been closer to fighting words. All right. There's also individual group libel, false and derogatory statements that tend to produce hate or prejudice about a particular group. Think of racism here. Statements that a certain race or creed or religion in some way is depraved. You don't go up to someone that is obviously a member of a religious organization they're likely to be challenged by that and feel the need to go ahead and defend themselves, maybe not in the most civil manner. So here, what we've got, and this is Bullis versus Illinois, 1952. I would know that case. Group libel is false and derogatory statements. Now, the key word there is false. Is false. If something is true in the context of freedom of speech, it's harder to limit that because it's true. So, truth in the expression of free speech is pretty tough to overcome because it's true, right? Now, again, when we talk about fighting words, you could say something to someone, for example, your baby is ugly. Your infant is ugly. Wow, that's some ugly baby. Now, in that case, you're not talking about some sort of group, right? But you are talking about perhaps fighting words. So group libel, again, is about a group that someone is a member of and you're attacking that group, but someone's commitment to that group is such that they might be offended by it. Another is defamation. With defamation, there's false and derogatory statements that tend to harm the reputation of the subject discussed. New York Times versus Sullivan, another case you should know. And again, we will go over these cases and you'll have the full case notes on them. So even if you don't get to them, you'll be able to read those cases. All right, so what we're talking about here with defamation is it's got to be false. There's a key word. It's got to be false. And the second part of that is it's got to be derogatory. So you're saying something that's not true, and it's derogatory, and you're saying this about an individual, right? So it harms the reputation of that particular individual, as discussed. In other words, that person, you've now said something that's untrue, that's false about that person, and it defames them. It negatively impacts their perception. It negatively impacts them, and it's false, right? If it were true, it'd be a different story. If it's false, then that's problematic. For example, saying that someone is a pedophile, right? Now, if it's true, it's true. If it's not true, that defames the person. And that makes it very difficult, in part because it's always difficult to prove something that's not true. How do you prove something didn't happen? How do you prove that something that was said is untrue? That's why in our legal system, you're innocent till proven guilty. And that's a very important distinction, because if you are guilty of something, people have to present facts. And those facts should lead to the truth, and that means that it should lead to some true statement. That being the case, one would expect that the defendant in that case would have to defend themselves, but the prosecution would have to prove the truth of their statements. Okay, again, it's about truth. So defamation is interesting because it falls in a couple of categories, and that should be familiar now, right? The first is public figures, and the other is going to be private people, private persons. Here's the thing, and sort of the guiding principle. If you're going to be a public figure, you have placed yourself in the public eye. And that means that you should expect criticism, right? If you're an actor, or you are a sports figure, or if you're a politician, especially if you're a politician, you have willingly placed yourself in the public eye. And that means that people will say things about you that are not true. Keep in mind that people can say things that are so clearly, obviously, not true, that the courts would say, nobody would believe this. And so they're not defaming you. Larry Flynt in the Hustler case, he, in his magazine, Hustler magazine, took Jerry Falwell and put him in a very bad light, saying he did all kinds of things sexually. And the court said, look, no one would believe this. This is so outrageous and so unlikely to be true that even though you're a public figure, nobody would take this seriously. And that the actual printing or publication of this stuff was obviously not meant to be taken seriously. It was a caricature in some way. So with public figures, actual malice is required. You have to really want to do harm. And that wasn't the case in the Hustler case. The statement that's made, you have to know is false. You have to know is false, or it's just got a reckless disregard for the truth. Right? We may not know that something is false, but we ignore the truth. We just simply are ignoring the truth, and that is obviously problematic. Milkovich versus Lorraine Journal is an example of that. Now, the actual public figure definition is it applies to statements of fact, where reasonable people would actually interpret the statement or opinion as based on fact. Larry Flynt, Jerry Falwell again, no one would have accepted that. So you have to have two elements here. We're talking about a public figure who put themselves out there, and that means they can be criticized. Is what's being said reasonable? Would someone actually believe it or not? And is it false? Okay, if it's crazy, wow, but it's true, there's no problem. If it is false, that's where the problem comes in. Now, what about private people? And I want to make a distinction here that you have semi-private figures as well. It's not just public figures or people that are not public figures. You have semi-private figures. These are people that, in the performance of their job, let's say, they're in the public domain. Now, what happens there is you can go ahead and you can criticize those people for their public function, right? Again, elected officials are different, and that's because they put themselves in the public eye, and the totality of what they do is public. But a public or semi-private person might be working in government and can be criticized for their function, in government. They didn't run for election. They took a job and they're responsible for something. They can be criticized for what they did. You can't attack them personally or go after them in their private lives. At least that's not permissible. So with private persons, malice is required. If a private person voluntarily places themselves into a particular controversy, then that private person becomes a public figure, right? For a limited range of issues, as I've just said, usually related to what they're doing. The second thing about private people is that malice is not required for private persons not involved in public issues, right? Now, think about that. They've not involved themselves in a public issue, in a public matter. They're private people. So you don't have to have malice intent here. You just can't do it. They are a private person, and you can invade their private lives. Now, suppose a private person gets arrested. That's a public record that, unless it's sealed by the court, as it might be in the case of a minor, it's fair game. So Gertz versus Robert Welch, that's an example of that. Now, when we talk about dangerous speech, we talk about unlawful activity, incitement, fighting words, group libel, defamation of public figures, of private people. The next one is the invasion of privacy. Now, disclosure of true facts that are private or harm the reputation based on false impression created by a statement. Okay, so let's look at that. Invasion of privacy, disclosing, right, of true facts, they're true, that are private, right, or that are private or harm to reputation based on false impressions created by the statement. So look, it's a private person. They do things in their private life that are not illegal. And yet someone has this information and makes it public. It does harm to their reputation. It was not meant to be in the public. They had a right to do it privately, right? And so the court would say you can't put that out there for the public. They're doing nothing that's illegal. They've not been convicted of anything or charged with anything illegal. They are a private person in their private life, in a private domain that is doing something that is not legal, and that is to be left alone. Now, you may find that the thing they're doing, the public might have a curiosity in, right? Nevertheless, they're a private person. So you may find out that a person, for example, likes to take a bath. An adult likes to take a bath with a plastic duck in the bath. A little odd, right? And someone finds out about that and puts it out there. And so there's an invasion of privacy. You're disclosing true facts that are private. No one has a right to know that. Why? There's a presumption of privacy. We all do things in our life that we believe are private, and they may not be things we would discuss or do in public. There's a saying that no matter how well you know a person, there are still a lot of things you don't know about them. Private thoughts and private actions are to be left, right? Left alone and allowed to be private. Imagine, if you will, that wasn't the case. That means anything that anyone did in private that was legal, right, would come under fire. Ask yourself if there are things in your own life that are legal and they are private that you don't want disclosed. You don't want people to know about, right? So you have a right to your privacy. Now, privacy is not mentioned specifically in the Constitution, but privacy is a fundamental right. If you look at it, right, privacy, we say, is in the penumbras, the shadows of the Constitution. You can't have any rights without privacy, the right to be left alone. You're doing nothing wrong. You're doing it privately. There's no intent for the public to know about it. And no one has a right to disclose that, even though it's true. If you take away our right to behave in private in a legal manner, for whatever reason and whatever way, if you take that away, you don't really have freedom. And if you don't have freedom, then what's the point of having freedom of speech? Really, it's freedom of expression, right? So what's the point of having someone express themselves if, in fact, it's going to be problematic? All right. So malice is not required, right, for private persons not involved in public issues or involuntarily involved in a public matter. If you want to go out and campaign for a politician, for example, you're doing that in public. You're moving out of the privacy, a zone of privacy, and more in the public domain. So you can be criticized more. The case is Gertz versus Robert Welch, and that's a case you should know. Okay, what about when we talk about things that are publicly apparent, right? That might not be considered private. You do things in public that are legal, but you still have a privacy right. For example, you're at a restaurant and you're sitting at a table on the sidewalk, and someone sees you eating, and you don't have the best manners, and so you're eating and food's going all over you, and you're behaving, well, maybe not with the greatest, concern about manners. They can't publish that. They can't publish that because even though you're in a public venue, you have some measure of privacy, and you're doing something that's perfectly legal. It's why sometimes you'll see in the news or wherever where there's videotape or there's even pictures, and there are faces in the background that are blurred out so you can't see them. If these people are going to be brought into the public, they should be asked, right? Are you okay if you show up in this picture? And if they say no, you've got to blur them out. Now, why is that? They have a right to be where they are, even if they're doing something that may not be so acceptable, right? But legal. So, for example, someone's having an affair with someone, and there they are, walking down the street together, hand in hand, or sitting and having dinner at the next table on the cafe or sidewalk cafe. They don't want anyone to know. Now, we may not like what they're doing. Some would say it's immoral, but it's not illegal. And so they have a right not to have their picture published. They have a right to be left alone. So those things constitute the major areas of dangerous speech, right? Unlawful activity, incitement, fighting words, group libel, defamation of public and private figures, invasion of privacy, right? Disclosure of true facts that are private or harm the reputation of a person based on false statements. Okay, so that's the sort of the general landscape we're looking at. Now I want to talk about the government, how the government deals with this idea of speech and how the courts view it. Okay, so the first thing we look at is content regulation. This should not be so unfamiliar, right? Content, context. So content regulation, the First Amendment prevents regulation of speech based on its content or the viewpoint expressed by the speaker. Laws that regulate speech on the basis of content or viewpoint are unconstitutional. Now step back and think about that. Why might that be? If you're regulating speech based on content, what is said, you're limiting speech. Look at all the dangerous speech, right, with false statements and the like. But a government limiting what you can say based on content without considering context is problematic. You'll notice that all the dangerous speech categories have a contextual base to them, right, as well as content. Content and context, that's what we really care about. So laws that regulate speech on the basis of content or viewpoint are unconstitutional. I don't like what you're saying, so you can't say it. The content is such that we're not going to permit it. That's really problematic. If you think about what's gone on, or what goes on at times, you get groups that are trying to suppress the speech of others. That's on the dangerous speech side. Here, if the government does that officially, you've got a content regulation. So, okay, in order for a law not to violate the Constitution, what elements does it have to have? First of all, it has to be content neutral. That means that a law doesn't distinguish between types of speech on the basis of what the speech is about, right? So it's got to be content neutral. You can't write a law that says you cannot say this. That's really problematic. Now, you may not say a particular thing in a certain context. It could constitute fighting words, right, on the private side. On the government side, if the government starts limiting speech, says you can't talk about this, that becomes problematic because they're taking away your right to freedom of speech just based on what they want you to say or not say. For example, you can't criticize the government. Any speech that criticizes the government is illegal. The courts would say that's unconstitutional, right? For another reason, which we'll get to later. It's way too broad. It's got overbreadth issues. But here, if you're going to write a law, it's got to be content neutral. It can't say you can't say this, but you can write something that says you can't incite. And then the court tries to decide if it's incitement or not. The second thing is viewpoint neutral. A law that regulates an entire topic or speech, regardless of the opinions or views expressed about the topic, is constitutional. It's viewpoint neutral, right? A law that regulates an entire topic or speech, regardless of opinions or views expressed about the topic, is constitutional. It's viewpoint neutral, right? An entire topic. For example, you can't divulge state secrets if you have access to them. And then if someone gives a report and there's a viewpoint there, so long as you're saying government, those documents or conversations that are private in terms of the government, not individuals, and they must be kept so, is viewpoint neutral. It's about a class of things. The other thing is content-based regulation. Now, the government may regulate speech on the basis of content if, and these are the two important things, right? First, the government has a compelling interest, sound familiar? Level of scrutiny. The government has a compelling interest to do so, and the means of regulation are necessary to achieve that interest. So, two things. You can go ahead and regulate it, but the government has to regulate the speech, the content, based on a compelling interest, and the court decides if it's compelling or not, and that the means they're taking to do that are such that they're necessary to achieve that interest. In other words, you really can't do it any other way. What the court wants to see is the least invasive way in the rights of individuals to go ahead, the government, to go ahead and limit that, right? Necessary. You got to do it this way. All right. The other is that the law regulates conduct and not the content of the speech associated with it. You can say what you want to say, but you can't do it in the middle of Manhattan during rush hour. You can't do it then. You want to have a parade. You got to get the government's permission because that parade invades the rights of others. During the summer, you see a lot of streets closed in New York for various, celebrations of one sort or another. You got to get permission from the city, right, in order to be able to do that. And the idea is you don't want to interfere with the rights of others who might want free access to those roads. Okay? So the law regulates conduct and not the content of the speech. It's not saying this particular group doesn't get to have a street fair. It just says you can't have a street fair of any kind without getting the approval of the city, right? So there you have a situation where it's the content-based regulation, right? The government can regulate it on the basis of content, but it can certainly regulate the conduct so long as it's not what? So long as it's not directed at a specific group. The next major area in freedom of speech, is prior restraint. And here, government regulation of speech before it has taken place is generally unconstitutional. You have to do something first. Prior restraint means that you're stopping someone from expressing themselves and from doing something, and that private restraint is not acceptable. Why? Because they have to do something first. Think about rights. If the government could stop you before you did something because they believe that if you do it, it's going to be problematic, how do they know that? They would have to make their case before a court of law, right? They'd have to be able to go in and say, look, this person, we can't allow this kind of speech. And the court would have to look at that and say, okay, so where might it be permissible? Private restraint on speech is permissible under two circumstances. One, national security interests are affected by the publication of a particular subject matter, right? That's Neer versus Minnesota. So think about that. The government should have a right to do that. You can't talk about this. If we wait for you to talk about it, sort of the horses are out of the barn and any damage that's been done has already been done. And you can't pull that back in. And it could do harm to the government, and that's problematic because the government is supposed to protect us, including our rights. So national security is one. The other one is where there's a government interest exists in securing a fair trial. And not Nebraska Press versus Stewart. So here, the government interest exists in securing a fair trial. They're saying you can't have this trial here. We've got to move it there because the government is trying to impose fairness on the process. The next major area we're interested in is vagueness and overbreadth, and we've touched on this. Government regulations that are vague or overbroad are unconstitutional as regulating more or less speech than they purport to prescribe. In other words, anything that's vague or has overbreadth is problematic. If it's vague, what does it mean? It allows the government pretty, broad right in terms of controlling speech if it's vague. What does it really mean? Plus, how can people really understand what their responsibilities are if the law itself is not clearly stated? So the court looks at that and says, this statute or law that's been written is vague. Right? And so how do you decide that? Well, the court looks at the statute and says if a person of common intelligence, right, cannot guess what type of behavior is being regulated, right, then it's problematic. We can't really describe what common intelligence is, but fundamentally, it's the court makes a determination that an average person, would understand what this thing means. And if they don't, then it would be limited. So an average person would be able to understand what the government wants them to do or not do. If it's too vague, you can't expect people to follow the law if an average person can't understand it. You have to write law in such a manner that it's understood. Now, those of us who've experienced statutes that go on for pages, we understand that those things are complex. Complex is not necessarily vague. Some issues do not lend themselves to simple language, or they're complicated issues and there's many different facets of it that have to be addressed. So we understand that the average person is not going to understand that. But there are other structures, organizations that will make that and explain it. Politicians themselves, regulatory bodies, experts in the field, right? The other is overbreadth. A statute is overbroad if it is worded in such a way that permits a state to regulate both matters that it may constitutionally prescribe and those that it may not constitutionally regulate or prescribe. In other words, the law as written is so overbroad that it's intended to do X, and it's so overbroad that it could do Y, B, and L. It just can be interpreted in such a way that it allows the government to go in a whole lot of areas that were not necessarily meant by the particular statute. Now think about that for a second. A particular statute has a purpose. And if it is so overbroad that it can be applied in a lot of other circumstances that may not fit the intent, the original intent, right? Then it's overbroad and overbreadth, and the state can't do it. So what is that? What are the courts really requiring constitutionally here? If you've written a statute, people should understand it so they know what the law is, right? That's why I think of ex post facto laws. Something written today that punishes for an action done yesterday. People yesterday didn't know it was illegal because it wasn't. Now you write a law today. Now they're aware of it. You can only try and constrain that behavior based on when the law is in place moving forward. To go back, people didn't know there was a law because it wasn't one. So think about that. That's got the same sort of element to it as overbreadth. It can be applied in any way you want. Of course, it's a different thing altogether because it's an ex post facto law. It goes back. And you can't be held responsible for breaking a law that did not exist at the time you did the action. The next category is obscene speech. This is very complicated. The closest we've come is the court has said, we don't, I know it when I see it, but I can't define it. There are certain things that we say that, okay, we can all probably agree that they're obscene. Trafficking, in child, sex, pedophilia. We can all agree that that's not acceptable, that that's a violation, that that's obscene, right? But how do we figure this out? Well, in Miller versus California, in the Miller case, the idea is that the average person applying a contemporary, meaning today, not going back 60 years and what the standard was then, a contemporary community standard, the expression is obscene if, right? So the average person, again, the common person, courts have to decide that. Applying the, if you will, I don't like using this word, but the moral standard today, right? If it appeals, if the obscene material or the likely obscene material, if it appears to the prurient interest. There are some people that will look at someone's shoes and that gets them, sexually interested. Now, we don't know. You just don't know what actually does that. The court has to decide. Not an easy thing to decide. That's why the court doesn't like obscenity cases. If the work itself is patently offensive, okay, what does that mean? You may find something very offensive that, other people say not so much. It's not a big deal, and they're okay with it. That being the case, the court again has to decide what's patently offensive. And the third, and this is even more of a slippery slope, taken as a whole, right? The work lacks serious literary, artistic, political, or scientific value. How do you define those things? Think of pornography, right? Who's to say it's not serious? in some literary way, or artistic, or political, or having some scientific value. For example, this is to instruct people about this type of sexual activity, so you're learning something. The court doesn't like it because you really can't define obscene. Remember this, there's this element of what the common folk think. The common folk think X. That means that we can rely on that interpretation, that the average person would agree. With obscenity, we don't all agree. Some people think, pictures of, women, say, on, topless on a beach, somehow that's offensive, that is obscene. Others would scoff at that and say absolutely not. Or think about, women breastfeeding in public, right? There are a lot of people that think that shouldn't be acceptable, but it is acceptable in all the states. Some states have sort of limitations on it, small limitations, but basically a woman can stop and breastfeed anywhere, and she's not responsible for necessarily covering up. What we've decided is that is permissible because it has another purpose, right? It doesn't appeal to prurient interest, they think, or it's not patently offensive, right? A child breastfeeding, and taken as a whole, there is a scientific value to it. That's a reasonably easy one. What about, we come to now, indecent and offensive speech? The government cannot prohibit the use of specific words in a public place where speech is not legitimately restricted. Words so protected are not obscene, but are merely indecent, vulgar, or offensive. The risk of censorship of specific words is the possibility of a government ban on the expression of unpopular messages. Cohen versus California. Another important case. Look, indecent or offensive speech, who's to say it's indecent? And there's always someone that's offended by something. And so how do you go about making that determination? Not so easy. Not so easy at all. So there again, indecent or offensive speech, the government can't prohibit that. You got to define it. And so you'll suffer from, vagueness or overbreath, perhaps. There'll be disagreement. What's indecent and what's offensive? Again, difficult to basically define. And if you can't define it, it's problematic. If you read court decisions, Supreme Court decisions, they're very careful to define their terms. They're very careful to say, this is how this is defined. Now, how do they do that? If it's a statute, they'll go back and look at the debates that took place, right? What were they arguing over? What did it mean? That's what they're looking at. So they can go ahead and they can define it based on that. Here's how the Congress defined this. They'll go look at the dictionary, right? How does the dictionary define this term? Whether it's Webster's or it's a legal dictionary, what do we think this word or this term means? And they'll also look in the public. How does the public define this? The court's very careful to define their terms because they're going to build their opinions around how things are defined. In law, it's very important to define the specifics. The court will look at that, and the court will try and determine what that means, and then they'll move forward from there. Okay. What about regulation of conduct of associated speech? So it's conduct associated with speech. It's not speech itself in terms as we normally think about it. Think of symbolic speech, which is one of the areas. Symbolic speech, basically, if law regulates expression based on its content, problem again, strict scrutiny will be applied to uphold regulation. So symbolic speech, you can't use this symbol, right? You can't use it in this way. I often think of the Mapplethorpe artist, who had a crucifix upside down in a bottle of urine. This was his artistic expression. That was offensive to people, but basically it was symbolic. He's an artist, and it was allowed. So basically, if regulation incidentally affects expression, or the government has an important aim unrelated to the expression itself, then there's a balancing test, and that's an important idea, is applied. Government interest is weighed against the impact of the law on expression. Very common, right? What was the government's purpose? Think about the various levels of scrutiny. What was the government's purpose here, right? And we have to weigh that against the right of someone to express it. If someone's expressing something symbolically and it's going to cause great civil unrest, then the government might have an interest in saying you can't express yourself that way, right? United States versus O'Brien, another case you should know. What about discriminatory conduct? First Amendment does not protect speech and attendant conduct that is motivated by bias or discrimination. Again, how does the court know that? You have to go to the motivation of a person. How does that get defined? How do you define that? Right? Motivation is difficult to define. It happens within a person's sort of mind. They make a determination. Hard to know what their intent is, but you have to kind of figure it out. The court does. The important one here is time, place, and manner regulations. Time, place, and manner. When you do it, where you do it, and how you do it, right? Time, when you do it, place, where you do it, and manner, how you do it. The court looks at that because some things in a different time or in a different place, right, or in a different manner might be perfectly acceptable. So the court has to look at when you did it, right, where you did it, and how you did it. So the government may regulate the time, place, and manner of access to locations that may be used for expressive purposes. Laws regulating access to property on the basis of the speech that is to be made on such property are generally unconstitutional. Again, the court doesn't like those sorts of limitations. Nevertheless, there's always exceptions, right? What about public forums? We're going to break it down to public forums, non-public forums, and private forums. This should be sort of very consistent thinking on your part, right? That public forums, whole different ballgame than non-public forums, and certainly different than private forums. So when we talk about public forums, these are forms specific types of public property traditionally associated with the act of speech or expression. Laws regulating speech in public forums may be upheld if they, now there's three things here, right? If they are content neutral, we know all about that. Second, narrowly tailored to serve a compelling government interest, very common. Compelling interest as a government against the balancing test, and allow for alternative channels of communication. Can't do it here, but you can do it over there. Then there are non-public forums. Right now, keep in mind, people think, well, non-public is private. It's not. There could be public, what we think of as public places, but they're non-public. For example, think of a military base. Okay, that might help. Non-public forums is property that is not traditionally associated with speech or whose primary use is not for expressive activity. Laws regulating speech in non-public forums may be upheld if they are, and there are two qualifiers here. One, viewpoint neutral, no surprise there. Reasonably related to a legitimate government purpose. Again, the level of scrutiny, the balancing test, all of that. And then we come to private forums. What about private forums? Private forums are property that is not open to the public at large or otherwise in the hands of private parties. Laws regulating speech in private forums may be upheld if states allow access to shopping centers, for example, for expression, but otherwise the Constitution does not apply to private property. There's private property that is so used by the public, shopping centers, that they fall into, they are private forums, but they're not private forums in the way we think of them as normally thought of. Okay, what about commercial speech? Any speech that is economically motivated or which does nothing more than propose a commercial transaction is protected. Now, think about this. We like truth in advertising. But go back to, the Hustler case. If it's so obvious, it's ridiculous statement that if you take this product, you're going to grow 2 feet. Everyone knows that's ridiculous. and it's and think of hyperbolic statements. If the average person would say, "Oh, come on, no one believes this. No one believes if you use this particular perfume, you're going to be irresistible." So we look at that and say, "Hey, come on, a buyer beware." When the public needs to know, right, and needs to be informed, think of an advertisement for a particular drug on the market. There have to be disclaimers. We have to tell you what's going on here because this is something that you may think, is going to help you, but it may not. And it does not it's not making a ridiculous claim. So there's all kinds of disclaimers at the bottom. They're moving very fast or someone's speaking very fast, but there are disclaimers. Okay? So basically, there is an exception. The government may regulate commercial speech that is likely to deceive or that is related to illegal activity. You can't advertise something that's illegal to do. Pretty straightforward. Okay, we come now to freedom of the press. We're not going to touch on, in terms of freedom of religion. We're going to just sort of end with this, with freedom of speech or expression. All right, the press has certain rights. Okay, we know that the press has certain rights. Whether they use them appropriately or not is not the issue here. They have special rights beyond those conferred by the speech guarantees. New York Times versus United States, the Pentagon Papers is an example of this. You should know that case. Government inquiry, right, is one. The press is not immune from subpoena or search warrants. Typically, the press will not respond to subpoenas, or they'll just go and plead the fifth. They don't like to, the press will not release their sources. They say it's fundamental to their function and to really exercise those First Amendment rights. Access to information is the second. The government must ensure that places traditionally open to the public remain open unless government has a compelling interest in closing. You see the compelling interest? That balancing always goes on. And finally, the press only has the same right of access as the public itself. There's no special sort of treatment in terms of the actual, place where they can go. All right, the idea of freedom of speech it's very complex, and I've tried to, bring it down to its fundamental elements. You could spend an entire semester or more just talking about freedom of expression. It's complicated. A lot of it, the court has to make decisions based on their perceptions, and consequently, it's not a nice, neat little package. And so there's all kinds of cases and there's all kinds of analysis that get done. What I'm going to do in the next lecture is lay out the cases you need to know and just talk about the particular issues. So you'll have some sense of that. And you'll see how they fit into the general structure of what we've discussed, in this lecture. The cases are important because they do illustrate. Remember, the importance of a case, law school or elsewhere, is that the court makes a decision that illustrates the principle. In other words, in applying the principle, they are illustrating it and telling us what it is. We like that. That helps us understand it. It helps us follow the law, and it helps us remain in our actions within the boundaries of the law. So what we're going to do is look at those cases next time and sort of get our mind around some of these principles we've talked about today by looking at the issue involved and how the court decided them. You'll also get those particular cases sent to you, the case brief sent to you well in advance of the exam so you can review those cases. Looking at this lecture or listening to it and looking at those cases that are involved in what we discussed will make it a lot clearer and will allow you to sort of piece it together in a way that's going to really help you prepare for the final exam. The cases themselves and how we apply them is really a review for the final exam.